Good afternoon, everyone, and welcome to this second Let's Talk POSH webinar here with TL HR Tech. We have with us three stalwarts in the industry and also our subject matter expert, Mr. Mahesh. We'll be talking about the statutory requirements as per the POSH Act and also multiple things around it. I'll quickly do an introduction. My name is Rishi. I head the marketing team here at TeamLease HR Tech. We'll start with Seema. So Seema Rawat has over 29 years of experience in higher education institutions and the aviation industry. She currently heads the program at BITS School of Management. She's also been a chairperson and an industry and an alum at the Narsi Munji Institute of Management. Welcome, Seema, and we really look forward to hearing your thoughts here.
Thank you, Rishi. Thank you.
Yeah, we also have Shalini with us. Shalini Gaba is a CHRO of Sports for All. Sports for All is a fully integrated digital plus on-ground multi-sport platform catering to over 40 plus sports discipline. It's something new that we are seeing that is coming up. She's held HR leadership positions in various organizations, including Intern Buddy, International SOS, and Celio. She's also been a part of many prestigious organizations, including Taj Hotels, Oberoi Hotels, and the Indian Express. Shalini, welcome, and hoping to hear some insights from you as well. Yeah, next we have Neha. Welcome, Neha. Neha is currently the AVP of sales at Loop Health. She has over 18 years of experience in B2B sales. She's also held leadership roles in companies such as Equifax, Miles AS, ServCorp, Catalyst Inc., and more. Welcome, Neha, and hoping for an insightful discussion. We also have with us the man of the hour here, who knows a lot about the POSH Act, Mr. Mahesh. He serves as a subject matter expert within TeamLease HR Tech, the services department. So Mahesh, if you could further introduce yourself and then get started. Thank you.
Thanks, Rishi. Good afternoon, everyone. This is Mahesh from TeamLease, and I'm a part of subject matter expert. And today we are going to touch upon the act called Sexual Harassment, Prevention and Redressal. And I would like to start sharing the screen. Oh, my screen is visible to everyone?
No, it's not, Mahesh.
I have shared it. Can you see the host disabled attendee to share the screen?
Mahesh, we'll get that.
Enable
started.
it.
Yes.
Right now, Mahesh.
Is my screen is visible?
Yeah, it'll be great if you could go to the presentation mode. Thank you.
Sure. Good afternoon once again. So today we are going to touch upon the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. And how the act applicability and relevant definition I have provided here. So what are the objective of the said act? So what is the purpose of having this sexual harassment, introduction of the sexual harassment of the women worker in the workplace, and how it has to be prevent or redressal and compliance, and what is the objective of it? It provides the protection against the sexual harassment of the women at workplace and prevention and redressal of the compliance of the sexual harassment for the matters connected therein with the incidental thereto. So this is the major objective of the act. And section 2A, agreed women. What do you mean by agreed women? Which has been defined under section 2A of the act, which is in relation to a workplace, a woman of any age. So this is very, very important, which has to be, we have to understand the age limit they have not defined here. So any age limit, women employed or not employed. So even employee who is not employed in the organization also will be considered as an agreed women as per the section 2A. So coming to the section 2F, which is employee means what? What do you mean by employees? In addition to the agreed women who are all being constituted as an employee as per the definition of section 2F. This would be regular, temporary, ad hoc, daily wages, either directly or through an agent, including a contractor or with or without knowledge of the principal employer shall also be considered as employee. Why there is a brief introduction about the employee which has been provided here is to make sure the sexual harassment may happen from any of the categories or classification which has been defined here. So coming to the section 2G, which clarifies on the employer means what? What? See, we have also
I mean, Mahesh, before we keep going with the definitions. So in the workplace, I mean, is it really important to get these definitions set, or I mean, do they play an important role, or any thoughts on this, Seema, to begin with?
I would like to. Okay, you are asking.
Seema. Yeah.
So the act, the way it is defining it as large as possible. The intent is to cover women who come and work for the employer and women who come in contact with the workplace. Suppose I'm a client who comes into the workplace to interact with this particular company, then I am also the aggrieved woman as per the act. The intent of the act is to cover as large a population of women who interact with the organization in any capacity. If I'm an intern and if I'm working, I'm not employed, but I'm also covered as an aggrieved woman over here.
Yeah.
So anybody who comes into contact with that employment in that organization, whether in the physical workplace or even in a workplace outside. So as long as I'm a woman, I'm interacting with this organization, whether employed full-time, part-time, contractual, temp, third party, any of those. I'm an intern or somebody associating for a very brief time period with not an employment contract, but a learning contract and so on is also there. Plus, if I'm a client or a customer who's coming into this workplace, I would also be an aggrieved woman over here. So the intent is to ensure that harassment does not happen of women in the workplace. Okay.
Understood. Any thoughts from you, Neha? There?
I think it's well covered by Seema right now on this one. It's just that it's been 25 years now, from the first time these guidelines have been made, and now it's been, I think, the 9th year that we have the act in place. So a lot has changed, but a lot has to be done.
Understood. So Mahesh, let's continue on this, and then based on the employer definitions, we'll get to Shalini to hear her thoughts.
Sure. Hope my screen is visible, Rishi.
No, I think there is a glitch today, Mahesh. Yeah, it's there now in the presentation.
This is very important, as rightly mentioned by our panelists. So what do you mean by agreed women? Why the workplace and employee? The definition is very clearly, precisely, explicitly stated who are all going to be employees and which all categories. There shouldn't be any ambiguity in future if something has happened or some harassment happened to the women employee, and if those categories are not, which is explicitly not stated in the section, definitely that would create an ambiguity. That's when the section is clearly explicitly stated about the employee definition and also agreed women. So what is, again, would like to highlight here section 2O, which is related to workplace. What all are going to consider as a workplace? Here, any department, organization, again, it is a very brief note on the workplace which has been considered here, like undertaking, establishment, enterprises, institution, offices, branch, unit. As such, private sector organization, private ventures, undertaking, enterprise, institution, establishments of society, trust, non-governmental organization. So these all hospitals, nursing homes, any sports institute. So all categories have been defined in section 2O, which is related to workplace. Workplace has been very briefly described here. This I would like to highlight. That's when again there wouldn't be any ambiguity in terms of the harassment happens, whether this has to be considered as a workplace or it is may not be a workplace. Even in the recent days during the COVID, the employee who's working from home also has been considered as the workplace. Here I would like to touch upon.
Mahesh, could you please, sorry to interrupt, go on the presentation mode? It's a little. Thank you.
Section 2N, I would like to emphasize what is amounting to sexual harassment. So these are all the 5 categories which has been defined under the section 2N. Physical contact and advances, demand or request for sexual favors, showing pornography, making sexually colored remarks, and other unwelcome physical, verbal or non-verbal conduct of sexual nature. So these are all going to be amounting to a sexual harassment in workplace.
Got it. So at this point, Shalini, would you like to come in? Like, obviously, some of these do in today's world get highlighted, by the employees, but some of them also go, under the marks here. So how is it that, organizations can do a better job in terms of, ensuring training or anything you'd like to comment on this slide in particular?
So just a point prior, I think you mentioned, which is about workplace.
Yeah.
So now we've seen the COVID wave and how the workplace shifted to virtual platform. So what's also important to know is that even in the hybrid setup, still the workplace definition would cover, an hybrid setup, a virtual setup, a physical on-site setup, as well as any activity which is getting extended. Maybe there is an off-site party that's happening. There is a post-work official party that's been organized. So all are under the purview of workplace, and that's so like any law which gets defined in India. If you would see, these are very broad description, and they may not be very pertinent. But when it comes to inquiries, when it comes to looking at context, we look at that in that particular, we look at the entire dimension of what a workplace would be. To your current point, which is about do these aspects that have been mentioned here, as my fellow panelists spoke about it, that these, these have been existing. And these were, of course, we've not yet, and I don't think so, the presentation covers about how did it reach to this stage, how did the evolution actually happen for it to even become an act. There is a lot of story prior to that, and I'm going to spare everyone of it. But I think it's very important to understand that how is an organization driving it. So, for example, if there are people-centric organization, it's even more demanding to go ahead and make everyone aware that what are the entire implications. So let me give you some examples here. So, for example, I'm currently working in a sports event/tech platform. So we have 3 dimensions to the business. This tech, there is also on-ground events, and there's a high investment that goes in people interaction. Now, from an organization perspective, because there are sensitivities where we're also dealing with government events, and we're also organizing events like Halo and National India, there's a lot of reputational goals which are there. And from sensitivity and sensibility perspective, we have been driving this as a safety agenda. And I think this is what I have done so far, that we didn't go ahead and pick up unconscious bias or a POSH as one of the agenda. We've looked at it as a safety agenda, that if we have to go ahead and make a workplace safe, what are those aspects that would flow? And from there, the thought leadership emanated, and we actually broke it down that POSH, yes, is mandatory. But even when POSH didn't exist, and I was working with Cello, which was a retail organization, so you can imagine the amount of intimacy that was required in terms of interaction between employer to employee. And that's when a lot of grievances in 2008, 9, and 10 that we had dealt with, and we had a grievance protocol. Now, those grievance protocols have POSH also embedded in, safety has psychological safety embedded in. So these are all interconnected. It's all on the maturity and the open-mindedness of an organization, whether there are call-outs or call to action around. So I can't give you a cookie-cutter answer to it. Again, it's the leadership is driving it from the perspective they want to create a safe workplace. Yes, this would be honored and respected or felt. But if they want to go ahead and look at it like a check in the box, which is mandatory now, so they would look at it.
Yeah, I think that's an interesting point, from a thought leadership perspective, because progressive organizations are making it a function of safety rather than just complying with a particular act. Any thoughts on it, Neha, from your side?
just to add here, it's just important to understand what could be included in the sexual harassment policy as such, because it means anything that goes against the dignity or the modesty of the woman. It could be as trivial as just a message which has been shared. And with the fact that now we've started working from home as a normal scenario, people are coming back to offices, but the hybrid mode does still exist. So a lot is, not very clear in terms of, especially for the women to understand whether this message was just a normal message. Should I take it as anything more? Should I report it? I think a lot has to be done on that sensitization, rather than just the training, as rightly said by Shalini, to be a tick in the box.
Right. Fair enough. So I think, Mahesh, if you want to continue with the presentation, then we can.
If I may, I just want to add something. In 2018 and 2021, Kerala High Court had some observations in a sexual harassment case. And then this whole thing that comes up is was it sexual harassment, or is it somebody's being very sensitive? Many times in organizations, we get this thing that, the person is being extra sensitive and, it wasn't meant like that and so on. So it's interesting that in 2021, the Kerala High Court not only spoke of whether the initial part that, it is actually something the woman feels, is, like Neha said, looking at the dignity part of it and so on. But they also added something called sexual intent. So was the intention to sexual, or was the intention not sexual? Now that really makes it very difficult for the committees to function actually. Now to get to the intent of it means detailed inquiry. And the organizations have to be open to, this inquiry, which could be much, ask a lot of uncomfortable questions. It could go on for a little longer. And at the same time, we have, the new observations which say that it all has to be confidential. Those are the, latest observations which have come out from another judgment in 2021, saying that you have to be extremely, confidential about the names, the instance, who's involved, so on. So over here, the organizations, the big task for them to become that they have to be sensitive to not only the complainant, but also the person to whom the complaint has been made against. And at that, at that perspective, the organization's overall culture towards how it looks at any form of harassment comes in. So if they have a very strict zero tolerance policy, they tend to kick in very fast and they take action quickly, and then, things move quicker. But if generally the organization does not place so much importance on, or let's say maybe it's not like a zero tolerance, it's a what if and it depends, then it does become, the task of the ICC and the role of the committee, internal committee, becomes extremely important, and the kind of people who are part of that committee then becomes very important. So I think Mahesh will possibly taking it up later on, but in these cases, the constitution of the committee, the culture of the organization becomes, because now how do you look at sexual intention and how do you find it out? So times are difficult, but this has always been a very sensitive area.
Yeah, and I think it will continue to be like this even in larger organizations, because I think somewhere there is a thin line between the sensitivity and the dignity part, where the committees are not ready to accept it yet. I think the progressive outlook still needs to be embedded, however much we may think that this is where we are. Anyways, Mahesh, could you keep moving?
As I mentioned, the workplace, what is consist of workplace, the company, and a workplace, whoever going to visit, like it includes the company guest house, hotel stay during official travel, client place, even work from home also treated as a workplace. This particularly I have specified here pertaining to the work from home also treated as a workplace. As I mentioned, during the COVID, where employees are operating from home, even operating from home also being considered as one of the workplace, and where we have also come across with several instances as such that their superior or the employees of that particular organization have been requested or have been informed or directed employees to switch on their videos if it is not necessary. Even employees have been, like women employees have been like harassed in those terms as well. So that's when the work from home also has been treated as workplace. overall employees, again, there are certain categories of employees have been considered overall employees, which is a full-time, temporary, contract, daily wages, trainees, interns, contractual workers, housekeeping, security, client representatives, vendor representative, volunteers without remuneration. There are certain employees who comes or interns, or some of them will come for without remuneration. Even such category also being considered as an employee here.
Understood. So Mahesh, if you could go back to the previous slide, and Shalini, I'd like you to sort of share your insights in terms of, because being a CHRO, how difficult is it to keep a tab on, even from a compliance point of view, whether or not they've gone through the POSH training, but also, as you mentioned, just from thought leadership point of view, that all these, like, employees, I understand, you have a strict control, but be it vendors, housekeeping, security, how is it that, you sort of manage all of this at a larger organization?
Again, as I said, the overarching thought is that it's safety, leadership, and then comes compliance part of it, which is, of course, making it mandatory and introducing it at every leg and every end of the organization scope of work. And that's when I think, from principal employer perspective,
Exactly.
when you wear that hat, everyone is your employee, and whether they are on your rolls, they are serving you for certain service duration, whether they are visiting you, whether they are your lawyers, and so on and so forth. So I think from that perspective, as an organization, or even in my exposure and experience, we have ensured that everybody is taken into consideration, not just by, attending a training, but we have educational posters which are displayed. So, it doesn't miss somebody's eye. There are awareness webinars that are being constantly conducted. There are sensitization and sensitivity training with the leadership that has been conducted. Now, here again, there are certain sensitive organizations which have got very open culture, which may be, so this is also emanating from culture. So for example, if there are structured manufacturing culture and leadership is very, directed in a certain manner, these are run in a very different way. But then there are organizational departments which have very collaborative setup. Okay, and that's where, some of these things can be considered as a joke. A remark in a corridor can be considered as, chalta hai, and so on and so forth. And that's where I think this has to be driven in a very, very standardized way. I'm coming to that point, that it has to be driven in a very extremely standardized way, that everyone who is under the coverage of employees will be covered, irrespective of whether they have gone through the training or not gone through the training. So that's the approach that we have taken. And or else we also go ahead and check it with the vendors whom we deploy, that have they gone through it. So for example, even in our forms, in our declaration and contract that we have incorporated that, they are POSH compliant. So we go ahead and ensure that, those checks are being maintained, at their end as well. And if we either consumers or we are providers of service, we are ensuring that we are doing it at our end.
That's great. So Mahesh, let's keep moving. And
Thanks, Rashmi. So one of the important section which I would like to highlight here is ICC Internal Compliance Committee, the section 4, and the employer has to have the internal compliance committee where there are 10 or more employees have been engaged, and the ICC to be constituted to the all branches. This is one of the important other point which I would like to understand from the forum perspective, because many of the companies, they'll come up with the internal compliance committee only in their corporate office or registered office, but that should not be the case. The ICC, wherever you have the branches, even your branch should also form the internal compliance committee, and this has to be like you have to have the ICC based on the locations. The consist of ICC committee overall, it consists of the ICC committee is, one is presiding officer, women who should be in a senior level at workplace, and minimum 2 members who amongst the employees, 2 members must be there, and 1 member from non-governmental organization, which is NGO, who is familiar with the related to the POSH related issues, or how to handle such sexual harassment in the workplace to the women. So the NGO should have the relevant experience in this regard, and provided that at least 1/3 of the total members so nominated shall be women. So which is half of the person should be women. And to hold the office for the period not exceeding, the presiding officer cannot hold his position for not exceeding 3 years from the date of their nomination.
Got it. So coming to you, Seema, on this, do you think these parameters, cover everything that you would expect from an ICC, or like, would you have some thoughts?
So, what the law says is pretty clear, in terms of the composition and all.
Yeah.
Where the, sometimes the challenge comes is that sometimes we have within an organization legal experts who anyways advising us. And then we also include them in our ICC because they are legal experts and they have knowledge of it. But you can't have somebody who's already associated with you. Then the person is not independent. So you have to make sure that even when you're looking at a legal expert, the person should not be having a current association with you or a very recent association also, because then they would normally be looking at what would be good for the employer and not necessarily in a impartial.
There's a conflict of interest.
Conflict of interest coming. So that comes in as well. And also second thing about the senior member. Now, it's very important that you just don't have a nominal female, within that committee. You have to have somebody senior, because if you look at the complaints which come in, they can come in for higher senior people as well. Now, how can you expect somebody who's so junior down the hierarchy to actually lead this committee? So that's why the provisions have been put up with some thought in mind to say that, yes, you need to have a senior person who will be in a position to actually do an impartial inquiry, hold the inquiry. And then, so ICC definitely becomes important there. But the challenges, like I told you, are we feel comfortable with people whom we are already associated with. So then in that case, we have the conflict of interest. Sometimes we just put nominal members just for the number, again, an issue coming up. And sometimes we put members for a very, very long time, actually, that also you can't have. You can't have somebody for years and years sitting in the ICC. There are provisions that you cannot have people, after a particular time. And that is another thing which I find organizations many times don't do it. So 3 years pass, then again, after 4 years, people wake up and say, oh, we haven't changed our ICC. So these are some things that organizations have to be a little bit aware of.
Got it. We'll keep moving, and then Neha, I'll come to you with the next part of this.
So coming to the next slide, which is section 6, constitution and jurisdiction of local committee. So when the local committee come into the picture and how the local committee shall be applicable. Local committee where the organizations are having 10 or less than 10 workers. As I mentioned, ICC committee shall be applicable where 10 or more workers or employees have worked in organization, but the companies which are having less than 10 employees, then they have to have the local committee, which is every district officer shall constitute the local committee, and the sexual harassment complaints has to be notified to every district officer. So all complaints has to be dealt with the local committee, and the local committee district officer shall have a discussion with respective petitioner or the respondent, and accordingly the further course of action will be taken up. So this is related to section 6, which is the constitution and jurisdiction of the local committee. Coming to the section 9, complaint of sexual harassment. When agreed women has to go for a complaint in respect of harassment, sexual harassment, which is in writing. The first thing is which the agreed woman has to provide in writing, and that should within the period of 3 months from the date of incident. When the incident has been taken place, within the 3 months of time, the complaint has to be raised either in the local committee or the ICC based on the applicability. Or further, there is within a period of 3 months from the date of last incident. In case if there is any incident which is happened or harassed series of incidents have taken place, and there is a certain timeline has been fixed, which is also again within a period of 3 months from the date of last incident. So where the agreed woman is unable to make, so there are certain instances where the agreed women shall not be able to comply in the ICC or LC, which is a local committee, then due to physical or mental incapacity or death or otherwise. So her legal heir or such other person may be prescribed, so they can raise the complaint and they can take up that particular harassment, the action which is required from the establishment. So I'll touch
Fine.
upon the section 10 as well, Rishi, then we can
Sure.
ask for the more insight from our panelist. Coming to section 10, which is a conciliation, there is another provision in the Act, which is a section 10. The local committee or internal committee can also take a kind of request, and this can be reconciled, or conciliation can happen within the respondent and the agreed women, where they can settle the case within the with, like, it is not required to take it up to the inquiry, wherein they can have a round of discussion and understand, and they can settle the matter between her and the respondent through the conciliation. So this is the one more provision in section 10 which can be happened, but however this has to be notified to the respective department which is related to ICC, which has to be notified to the department, and to the district officer which is related to local committee. Yes,
Right.
Rishi, you can.
Yeah. So we'll get to the constitution and jurisdiction of local committee, but the complaint of a sexual harassment. So how? I mean, Neha, if you'd like to come in, Shalini, feel free to chip in as well. How can organizations make it frictionless? The whole aspect here. Yeah.
Neha, you can.
Sorry, you're not very clear, Shalini. I think there's an issue with your audio.
Can you hear me?
You want to try speaking again?
Yeah. Can you hear me? All right.
Yeah.
So something that I want to add on the conciliation part of it is that whenever there is a settlement which is happening before the entire inquiry gets established, in front of the company, there is a clause which the law mandates that no conciliation will be bound by monetary settlement. So I think that's very, very important to go ahead and mention at this stage, that that cannot be the basis of conciliation. And this is more of a discussion that happens, to arrive at consensus. So that's all I wanted to say. Over to you, Neha.
I think it's well covered under the discussion that have been had with Mahesh, I think.
I wanted to, Shalini, if you want to comment on how organizations can make the complaint process a little more frictionless here, or do you think it's already there? Any thoughts on that from you too, Seema?
So I don't think so. There is a very defined way how the entire process is done, and that's already defined by the law, that there is a committee, there will be a procedure, and that's why trainings are mandated and conducted separately for internal committee as well as for employee. There is a difference, and the way it's been driven, and that's to go ahead and give a very standardized approach in terms of how this has to be managed. And that's and also to reduce any kind of precedences. So as I said, that again, everything emanates from culture. How do you do it? How do you take this sensitively? And do you want to go ahead and still have grievance protocols? So for example, just now we picked up this point about conciliation. Okay, so a lot of time it may not be a full-fledged inquiry, and it could be that the consensus was on both the end. For a joke to be exchanged. So there are scenarios like that where, as a committee, we will also go ahead and see that was there any kind of frequency of lewd jokes or remarks in the past, and were they acceptable or not acceptable? Did they reach the stage of consensus, not reach the stage of consensus, and so on and so forth. So I think from awareness and maturity perspective, that's all I can say at this point of time, that how this can be looked at. Rest law is very, very clear and defining it in a very broad and a very succinct way of how this has to be managed.
Got it. I think thanks for that, Shalini. So before we move on, just a gentle reminder that we have over 60 viewers for this panel discussion, and we already received some questions. I think the participants can continue to ask their questions, and we'll dedicate the last 10 minutes of this webinar for answering the questions. And our panelists, along with Mahesh, will be more than happy to answer those questions. So Mahesh, over to you.
Thanks, Hashi. Now coming to the section 11, inquiry into complaint, how inquiry shall take place, and when the complaint has been raised by the agreed women, within how many days the inquiry has to be completed, which has been defined as within 90 days the complaint has to come with the resolution. So this has been provided, and further provided that agreed women informs the internal committee or the local committee, as case may be, that any term of condition settlement arrived has not been complied with by the respondent. So what needs to be done, which has been defined here and provided further, both the parties or employees or party shall during the course of inquiry be given an opportunity of being heard. So both the parties has to be provided we have to hear out from them the findings and shall make the available to both the parties, enabling them to make a representation against the findings before the committee. So I'll move on to the next slide. Yes. This is related to only inquiry into the complaint and what is the periodicity has been specified here.
Yeah.
So action during the pendency of the inquiry. So what action to be provided? So during the pendency, the agreed women, so whether the agreed woman has to be transferred, because such instances have come across in many of the establishment where the respondent and the agreed women, if they are working together, that will create some other the conflict between both of them. That's when there is a section 12 which very clearly explicitly stated that where the agreed women can be transferred to a different office in case if they have a workplace in other locations close by to the women employer wherever, or it is based on the discussion with the employee, or in case if such arrangements are not available, can the agreed women can grant a leave for certain period or until the inquiry gets completed, or for the 3 months period of 3 months which has been specified in the act, and the grant of such other leaves agreed women may be prescribed. So this is what, and the leave granted to the agreed women shall be in addition to the leave what she is entitled for certain leaves, which is the earned leave or privileged leave, sick leave, whatever. So which in addition to that, this particular the leaves also to be extended to women employee, which has been prescribed in section 13. So Rishi, anything you would like to ask upon this?
Yeah, I mean, just panelists are free to comment here, or we can keep moving. I think these are more of facts here. But Seema, Shalini, Neha, just feel free. Yeah, if you guys want. All right, let's keep moving, Mahesh. Yeah.
Thanks, Rishi. And coming to section 13, which is an inquiry report, when the inquiry report has to be submitted to the authority or by employer to the district officer, which is period of 10 days after the completion, after arriving at the inquiry report. Once the resolution has been taken, then within 10 days time, the inquiry report has to be submitted to the authority or by the employer.
Okay.
So, section 14, which is punishment for or the false or malicious complaint and false evidence. So during the inquiry by IC or LC, if arrived at a conclusion, allegation is a malicious or made a false complaint or produced any forged or misleading document, may recommend it to the employer or district officer to take the action against the women. So there are evidences or there are instances where women employee might have provided a false harassment against the respondent, and how this has to be dealt, though they have not briefed about how it has to be dealt. Otherwise, there is the action to be initiated by the employer or the local committee, the district officer, against the woman, which precisely stated in the section 14.
So, is there any provision there, Mahesh, of appealing against this? I mean, any such instances or cases that you'd like to highlight?
Cases, no, I have not taken any relevant cases on this.
Okay, but there is provision to appeal against, like for the whole, malicious complaint.
Yes, malicious complaint.
Okay.
Just to add here,
Yes.
Just to what Mahesh was saying. So we have to know that the internal committee IC gives a recommendation.
Right.
Okay. And the organization already has some rules which are for its conduct of its employees. Now, normally in that rules, it is written that, complaints of sexual harassment would also be taken up and so on. So when the internal committee gives the recommendation, the authority on the other side, whoever is the disciplining authority, has to either accept the recommendations or in writing say that we are not accepting of this recommendation. Okay. Now, when you look at something called an appeal, The appeal part comes in once the discipline authority has given the punishment, whatever that may be.
Yeah.
But the IC does not get involved in it. The internal committee is constituted for a specific purpose of a specific complaint. I mean, it's constituted generally, but it takes up a specific complaint and it gives a recommendation for that specific complaint only. So it is not engaged with again. It has given its recommendation. And then the authority, if it does not take the recommendation, has to give in writing why it would not. And if it takes a recommendation, it goes on and gives the punishment as it deems fit. It probably has already written it down in their standing orders that you normally have, or at least in the rule book if the company is not covered by the Industrial Employment Standing Orders Act. So that is how that's my take on it.
Yeah, I think that's thanks for that.
Neha,
sure.
Made by Mahesh. There is also an aspect of counseling or some kind of psychological assistance which should be given to both the person who is the victim and also against the individual who has been complained as the harasser, right? Because this is a really sensitive matter, and let's not crush the principle of innocent being unless you prove them guilty. There is still a reason why you should be going extensively inside it. And while working with Loop, we have a panel of doctors who usually interact with employees as a part of the employee assistance program. And we see a lot of, times HR now utilizing this platform because we do have people who are psychologists who are available 24/7. And it's been noted that the individuals undergo depression, anxiety, and even cases of, post-traumatic stress disorders as well. This causes a lot of challenges in the individual's health, personality, and the very base of it, to get the individual back to work into a normal scenario. I think all of this is in black and white, but a lot needs to be done in terms of the aspects of counseling the individual and nurturing the individual to live up, because it's a long time from the time the individual decides to make a complaint to the time a judgment is taken or a decision is taken on that aspect, right? So I think counseling should play a real important role here. And since we are talking to HR and not the lawmakers, I would also insist that HR should have forums wherein the individuals are nurtured in such a fashion that they have opportunities to come out of these instances.
I think that's a great point you make, Neha. I think with especially with mental health being a priority for progressive organizations these days, I think it becomes a very quintessential point. Great. So Mahesh, can we continue to move on? We have another 5 minutes before we start answering questions. So maybe if you could cover some important aspects, need not be in the flow.
Okay, Rishi. So one of the important point which cited by our panelist, which is section 16, prohibition of publication or making known contents of complaint and inquiry proceedings. So this has to be kept it very confidential. Any case which has been like agreed women has raised the sexual harassment, that cannot be published, and this has to be maintained, the confidentiality and document has to be maintained very confidentially. And this is the one of the important point which our panelists also cited, and they have provided more insight on this. And coming to section 19, which is duties of the employer. What is the duties of the employer? Is the employer has to provide a safe working environment, workplace, which shall include safety from the person coming into the contact at the workplace, and display. The internal committee has to be displayed in a conspicuous workplace in the organization, and also he should give more he has to give more awareness in terms of the sexual harassment, and there should be a kind of e-learning, or there could be a frequent session on this to ensure that the women has been protected and this kind of concerns will not arise in the organization. This is the major duties of the employer. In addition to that, employer has to file a returns which have the compliance related to the complaint. Annually, the returns has to be filed. So committee to be submit the annual report, then the annual report has to be submitted to the district officer by the local committee, by the employer again to be submitted to the authority.
And penal Mahesh, since this is a part of, you mentioned, this is a regulatory requirement as well, and these are part of annual reports. So I wanted to understand here from you, Shalini, or Seema, Neha, feel free. Like, how important does a board of director or a governance model or an architecture of an organization play a role here? I mean, are they looking at just as a tick box activity, or are they playing a larger role here from a because culture flows from top to bottom. So how important do you think the governance model here is?
The short answer would be both.
Okay.
Because I think while it was articulated to go ahead and provide assurance to women, and I think there is a question in the question box as well, why men are not covered, and because we've not really looked at the evolution and the history about why this law was articulated, that question has come up. But just to go ahead and say it from the perspective of, yes, from governance perspective, this is mandatory now. When it comes to filing the reports on at the year-end basis, if you want to go ahead and go for any kind of investor readiness, for your business, these are mandatory policy, and these are like one of the first, immediate attention action items, that get picked up. But the other side to the coin is that because these are so important now, and also who are your leaders? Are they looking at driving this only from the governance perspective? And what exactly is governance? Is governance law, or is also governance about we are ensuring that it's managed well, it's disseminated well, there is sensitivity and sensibility, as I keep saying, it is being done. So again, it's a very, very independent view, having an advantage of work with organizations, and also the liberty of being in the leadership for so many years, whether it's driven in a certain way, through my colleagues and myself. But again, I also know a lot of startups. I've been a consultant to many where it's also run from the perspective that, okay, we are getting investor ready. So again, each one to its own, related to it. Yeah, for me, it's both.
Okay. I think we have 1 or 2 minutes, Mahesh, if you want to cover anything, or unless the panelists want to come in. Yeah, sure, Seema, go ahead.
To your question earlier, as an independent director, you'll be surprised as how much the board, how many queries are coming up regarding, what kind of safe working environment one is making. And right. If, so it is seen extremely seriously by the board. And boards are asking, questions to the management about how they are looking at, especially if even if no sexual harassment complaint has come up, but if it is there in the report anywhere, what kind of complaints were made, general, one has to write there that how many complaints were made, how much have been, sorted out, whatever is the level. A lot of questions are asked at board level. So in that sense, I just want to use this platform to tell you that the governance mechanism regarding safe working environment for women is taken very, very seriously at the board level. And managements are asked very tough questions now. So earlier one would feel that, questions would be regarding sales, market, other growth and all, but you'll be surprised how much HR questions take up space when it comes to board meetings. So it is taken up very seriously in most organizations. And I think it's kind of becoming a norm in almost all now in terms of taking it seriously.
That's good to know, and thanks, Seema, for bringing that to light. I believe, Mahesh, we cannot complete the entire presentation at this point, so we'll jump to the questions. We have a couple of questions. There's a third question. Would you like to pick it up, Shalini? The question on if any of the branch has less than 10 women, do we need to constitute the internal committee for that branch? Mahesh, or you think you're in a better position to answer that?
Yes, Rishi.
Yeah, you can stop sharing, Mahesh. Yeah. Just a minute. It's up on the top. Yeah.
Hope my screen is not visible now.
Yeah, it's not. So, Mahesh, you want to answer that question?
Just a minute, I'm moving on to the questions.
Yeah.
Why only women have you not added men and others?
So I think that is something that Shalini already answered with respect to, there's a long history to why POSH Act has come, and perhaps at a different webinar, we'll start the conversation that way. Maybe you could jump on to the next two questions.
Okay, if any of the branch has less than 10 women, do we need to constitute ICC committee for that branch is the question. And this is, again, we need to find out how many employees are working in the organization. Otherwise, Act precisely cited that the ICC committee has to be there based on the location specific. If there are employees who are working, 5 employees in that particular branch, then out of that 5 employees, how many are women employee or men employee, based on that, the committee has to be formed. So in case if there are no women employee, then we have to take it from the different branch, the same such like a presiding officer as a woman, or NGO is going to be a common. Other 2 member we need to say, if women is there, definitely we need to have a branch over there. Otherwise, then since the the members have to be women, we have to see, look at it, the branch, how many women employees are there. Accordingly, we have to have the branch there. Like I mean to say, ICC has to be formed. What is the general practice when we have terminated an employee owing to sexual harassment case? In this background verification, should we disclose this to the next employer, or should it be a contravention of any article under the Constitution of India? It's a kind of typical question. Yes, definitely. But otherwise, this information has to be maintained confidentially. If any respondent or any employee has been considered who has sexually harassed the women, yes, that will be like the agreed women would have been given a written complaint, but those information has to be confidentially maintained. But further, it is up to the employer discretion whether to intimate this when employee is joining the other organization. Nowhere it is cited, but again, this has to be dealt the case-to-case basis.
Okay, so I think we still have 3 or 4 minutes before we sort of wrap this session up. So just wanted sorry.
I'm sorry to pause you. I would like to highlight to the entire forum on the she box. Like a couple of states have initiated, which is the grievance where they can raise the grievance. Like the Telangana government has come up with the she box. So she box, which is any sexual harassment that can be raised through portal itself, that has been initiated. Even the central government also come up with the she box. It is not the she box. Telangana, it is a Telangana she box, and the central government, but that is open for not only the employee who has harassed in the workplace or in the organization, even in the other place also, the women can raise a complaint. Similarly, few more states, which is Haryana has come up, and UP has also come up with this kind of online portal where the women employee can lodge their complaint. And also a couple of states have also intimated related to the ICC committee, information has to be notified through online. Specifically, Telangana and the Delhi also come up with those information has to come. Even Karnataka, there is a separate notification which clearly says that ICC details has to be notified to the department. So I just would like to highlight this.
Yeah, I think it's interesting, Mahesh, that you bring that up, and you said it has to be submitted online. So just before we end this, I wanted to ask, like, how important a role technology can play here. We all know technology brings in a lot of accountability, transparency within the system. So, I mean, a good platform which allows these structures to come in and complaints to come in without any, human intervention. How important? So, Shalini, if you want to share some thoughts, we'll then jump.
Can I share my screen? I have an article on that.
Yeah, sure, Mahesh, but I think we have a couple of minutes only. So we'll first hear the thoughts, and then if time permits, we'll go on to that.
So, the question of technology arised, when COVID happened, when pandemic hit, and I'm sure Mahesh is referring to an article related to that, but from scalability perspective, technology is an enabler here, but these are, first, what is the origin of the subject? The origin is because of human intervention. So technology at no stage can go ahead and replace humanization of the entire aspect is something that we need to go ahead and look at mind. So that's why a lot of time, when we do these e-learning, I'm not a very big advocate of e-learning modules. It's only done from, a scalability perspective and to be able to reach every every head count we have in the organization. However, coming to the topic, technology can only work from scalability perspective, but it will at no stage. And yes, because our government is so pro-digital, these platforms have, emerged, and which is a great sign. This entire aspect of ensuring that it's just not at the mercy of an organization, but one can go ahead and reach out to these forums. So I think from that perspective, it's great to go ahead and look at technology, as an option, surely. But again, human intervention is definitely what would take the lead.
Yeah. Anything from you, Neha, Seema? Just feel free. Parting thoughts. I mean, just overall on the subject.
And I think just what my panelists just said, and what Shalini and Neha have already just mentioned, and Mahesh as well. See, the intent of the act has to be seen. At the end of it, legislation can only do so much. Organizations have to come in and, the objective is to create safe working environment. And safe working environment, not only for the women, but for the men as well. So in that case, transparency of the processes, robustness of the processes, the kind of, awareness campaigns one can do, what kind of, walk the talk the leaders do. I think all that will help a lot. I mean, the law is there and it's pretty straightforward in some sense in this particular case. But I think organizations have to have a overall holistic view to say, okay, we want to create a safe working environment so that our people are productive, they're happy. And with that direction, then look at what kind of interventions they do and what kind of processes they take up. So there's a lot of scope to do beyond the act over here. And some organizations definitely, when it comes to protecting men also in terms of harassment, have moved ahead in that. The law does not stop anybody from making it more. These are just the most basic restrictive mechanism that is over here. So I think in that end, organizations have to see what their constitution, what the demographic is, and how best to serve the interest of their employees by creating a safer environment.
Thank you. Thank you, Seema. All right, Neha, anything from you before we wrap up?
Instances of, the nature of work as well, such as in hotels and restaurants. You'll find rarely a place in hospitals as well, that wherein a complaint would be made on a regular basis. If you look at the statistics, it's the lowest in these industries. Now, there are a large number of people coming in, going out every day in these situations. And again, these are complex places, as rightly mentioned by Shalini. So it requires a lot of attention. It requires a lot of understanding of the policy for it to be more effective. And I think strong implementation of the act will only help you to boost the morale and improve the entire organizational culture in whole.
All right. I think that's a great point, Neha. And I think, organizations specific to these industries can look at sort of improving, the entire mechanism around complaints for sexual harassment. And I think with that, we've sort of come to the end of our timing as well. But thank you, Shalini. Thank you, Seema and Neha, for sharing valuable insights, and Mahesh as well for bringing up, all the technical know-how around the subject. Of course, we couldn't cover it completely, but we will have a second session specifically on POSH as well. And we'll try and continue from where we left off. I'd like to thank all the participants on behalf of TLHR Tech. Thank you for joining in, and more importantly, staying on till the end of the discussion. It gives us a certain sense of, boost that, yes, we are talking, a lot of relevant points there. So thank you everyone for joining in, and it's great to have you. We'll see you soon at the next webinar as well. Thank you.
Thank you so much, Rishi.
Thank you.
Thanks, everyone.
Thank you.